You hit that record button.
The broadcast is now starting. All attendees are in listen-only mode.
So a little bit about me. I'm going to be an attorney here in 2 weeks. Woo, pretty excited. I've clerked at Jeff's law office for about 2 years now and learned a ton along the way, mostly about LLCs and corporate governance. And while I was in law school, I emphasized corporate law, business planning, and taxation. So I guess that makes me at least relatively qualified to talk on the subject. I'm certainly not the end-all be-all expert. But we'll jump right into it here. Today we're going to be covering 4 types of LLCs. So standard LLCs, series LLCs, which are a pretty unique critter, disposable LLCs, S-elected LLCs, and then we threw in a bonus. We're going to talk a little bit about IRA LLCs, which are another really interesting tool. And all of these are kind of talked about in the context of real estate investments, since that's what most of all of our clients are doing right now. And these are all really useful instruments for them. So jump in here. So kind of when you're going to set up an LLC, you want to ask yourself some questions. Most people do it for asset protection purposes, especially in the realm of real estate investing. So you just kind of want to ask, okay, what are you protecting? Who are you trying to protect it from? Where is the asset that you're trying to protect? When are you trying to protect it? Why? And then kind of how long are you planning on owning it? And how do you want to protect it? And the answers to these questions will dictate what type of LLC you ought to be setting up and how you ought to be using it. So it's pretty basic. So some of the reasons that people set up an LLC, first and foremost, is a tax shelter. LLCs get a number of benefits that people do not when filing taxes. A big one is the ability to write off necessary and ordinary business expenses. And that's really useful for lowering the amount of taxable income the LLC generates for the year. Another massive benefit of the LLC is protection of the business's assets. So if you're in a business such as real estate investing, and a lot of what the business does is hold assets, you want to be able to protect those. And LLCs are an excellent vehicle for doing so. Another protection that you benefit from when you set up an LLC, if you set it up correctly, is you get to protect yourself. You get to protect yourself from anything that the business is doing. You get to protect your home, your vehicles, bank accounts, retirement funds, all that kind of stuff. Very important to compartmentalize risk, and LLCs help you do that. Another great feature of an LLC is that it survives death. It can pass through death or through the death of your partners and continue functioning, which is really beneficial for your heirs or people who stand to benefit from the hard work you've done and the investing that you've done. Another great thing about an LLC is the ability to resolve disputes between parties. Anytime you don't memorialize agreements you have, quickly, small disputes turn into big disputes, and those turn into he said, she said kind of affairs. And the neat part about an LLC is all that's kind of taken care of for you. The LLC will tell you how to deal with disputes. It will have provisions in there allowing partners to be bought out, allowing people to sell their shares, things like that. That's a huge benefit, especially when you're doing anything long-term over the course of 10, 20 years. Disputes arise, and they have to be dealt with. And perhaps the best part of an LLC, you get to pick a cool name. My LLC I set up for investing purposes is called Pumpkin Pie. So that's often the hardest thing for our clients is thinking of a great name. All right. So what exactly is an LLC? It is a limited liability company. There legally a relatively new invention that came out of Wyoming in the mid-'80s. The legislature there wrote up a series of laws that allowed for the creation of a new type of business entity, where before there only existed partnerships and corporations. They wanted something that was simpler, more flexible, and really accomplished what most small business people are looking to do, and that is be protected, benefit from the tax breaks that a corporation gets, and be able to do business simply without kind of all the unnecessary complications of a corporation and without a lot of the liabilities that partnerships can have. So it's a very simple, flexible company. It's taxed like a partnership is, and that is to say it's a flow-through entity. So anytime, and let's see here, we had one more person jump on. Richard, hopefully you can hear me. If you can, just go ahead and raise your hand while I talk or leave a comment, and you can go from there. But anyway, so an LLC is taxed like a partnership. It's a flow-through tax structure. And that just means anything that the LLC makes in terms of income for the year will kind of take its normal deductions and exemptions, and then whatever's left over passes to your personal income statement. So we'll talk a little bit about that here in the next couple slides. So what actually makes an LLC? What's kind of the meat of the LLC? It's two kind of big operative documents. One is the Certificate of Organization, and that's the simpler and smaller of the two. And all that is a collection of information required by the state to be filed before they will recognize your entity. And so it's just simple information. It's a contact person. It's an address. And then they try to get more information than that from you. You can significantly reduce the amount of information you have to give the state by not filing online. They kind of try to get you there and get more information than they really need. And then, of course, a set of filing fees. And that sets up the business in the eyes of the state. They'll say, okay, this is an entity and we're allowing it to do business in our borders. Now, the other often overlooked and extraordinarily important document is the operating agreement. That is the actual business. The operating agreement will spell out who owns the business, who manages the business, what their respective duties and obligations are. It spells out how voting works. It spells out when meetings are to take place. It has provisions in there to protect the members from each other, to protect the members from lawsuits, to protect the manager from lawsuits and from the business. And it really breaks down what the LLC is about. And so without an operating agreement, you may be doing business in a recognized entity, but you're not going to benefit from any of the protections of having an LLC. The operating agreement is the single biggest piece of evidence you can give a court or someone trying to sue you to say, hey, look, this business is real and it's legitimate, and if you care to find out why, you can sit here and read through my 40 or 50-page document that spells that out for you. So that's the real operative document. The certificate just gets you legally recognized. The operating agreement actually builds the business. So we've talked a lot about the protections that an LLC grants. And so we're going to break that down a little bit, what those mean. The biggest protection that you get when you set up an LLC is limited liability. Limited liability is the idea that members or owners of a business can't be held responsible for acts of the company. Okay? So originally, way back in the day, the only real entity you had were partnerships, and you had just general partnerships. And in a general partnership, you pool money, funds, you work together to achieve some kind of enterprise. The problem with those is when when the business does something that subjects it to liability, that liability would pass right through to the members. And so maybe you're in a partnership of 10 people, and on the day that they vote to do something, you're out and you didn't vote on it, and you come to find out that the thing they did was illegal or harmed somebody. Suddenly, you're being sued personally for something the company did. And so Corporations were kind of the first instrument, and then later limited liability partnerships that carried the limited liability protection, just saying that, okay, if the company does something, it bears the responsibility for its actions. And the owners of that company do not or should not. So LLCs incorporate that limited liability protection from corporations and from limited liability partnerships, and they carry it as well. So in the context of real estate investment, limited liability means if you own a property in an LLC and the property was negligently rehabbed by yourself, let's say by the company, and the property burns to the ground and someone is hurt, the LLC bears the legal responsibility for that action. The people who own it do not. Now, it's important to note that that's not bulletproof. It can be close to bulletproof, but it can never be 100%. We'll talk about that in a little bit. We'll talk a little bit too here about charging order protection. And I've got a whole slide about that, so we'll get to that in just a second. But basically, the way that you lose the protections, the reason that they cannot always be 100% bulletproof, is that the idea exists that if a company is not run correctly, if it doesn't actually look like a company, talk like a company, and act like a company, a court of law reserves the right to say that it's not a company. And that's called piercing the corporate veil, and you probably hear that term a lot. So in order for a company to receive the limited liability protection, it actually has to be a company. It needs to be recognized by the state. It needs to have an operating agreement. And it needs to be run like a company. There have to be votes taken. There have to be meetings kept. And we'll get to that in just a second. When a court decides whether to recognize an LLC in terms of not allowing a plaintiff to sue the members, it engages in what's called an alter ego analysis. And the alter ego analysis just says, okay, do we think that this is a flimsy sham company set up at the last minute of the midnight hour so that this guy could get out of a lawsuit? If all the evidence seems to indicate yes, then we will strip the limited liability protection from the company and we'll allow the people affected to sue the members directly. The kind of flip side of that is ultra vires analysis, which just says if somebody who is legally responsible to act for the company does something that the company doesn't want collectively, then the court reserves the right to protect the company from the actions of that person. And we can talk about that more after if you'd like. It's not critical in terms of real estate investing, but we can get more to that. So when a court looks at the alter ego analysis, it looks at accounting, corporate governance, and signatures. And so kind of a piece of reassuring evidence for real estate investors is that any company, so there's never been a case, a legal court case brought in Utah where it's been decided that a company that has engaged in accurate and thoughtful accounting, correct corporate governance, and assigned their documents correctly, such a company has never lost its limited liability status. Okay, so let that sink in. That's important. If you run this company right, in Utah at least, there's never been a case where a company has lost its limited liability protection. And the problem is most people don't run companies correctly. They don't pay attention to the accounting. They don't keep accurate records. They don't engage in proper and timely corporate governance. And they often don't sign documents correctly, right? Because they don't have access to the ongoing support that people need to make sure they're doing that correctly. Somebody sets up the LLC or they set it up themselves. They think, great, I set up the LLC. Now and for all time, I get all the protection I ever want out of it. Not true. You have to run the company correctly to get the protection, okay? So another protection we're going to talk about a little bit here is called charging order protection. So this is the mirror of limited liability protection. Limited liability protection says that a person cannot be held accountable for the actions of the company they own. And likewise, charging order protection says when there are multiple members in an LLC or another type of entity, one member cannot be held accountable for the actions of another member personally. So the example we always use is, let's say myself and Bruce both own an LLC jointly. And personally, one day Bruce is out in his car taking a pleasure cruise, and he hits a bicyclist. Well, that bicyclist is going to sue Bruce. And he can sue Bruce for anything Bruce owns. Well, Bruce is a half owner of the LLC that we share, so he can normally, legally, sue Bruce for half of his ownership of the LLC and take whatever's in the LLC, sell off assets, satisfy that judgment. Now, because Bruce and I own an LLC jointly in the state of Utah, that plaintiff, that bicyclist, is not going to be allowed to do that because I'm going to benefit from charging order protection, which says that I'm an innocent partner, I'm an innocent member of this LLC. I didn't do anything wrong, and so it's unjust for my interest in this business to be affected by something dumb that Bruce did. Now, Bruce, personally, he can still lose anything that we don't own jointly outside of the LLC. The bicyclist could get Bruce's house, he could get his car, he could get his retirement accounts, etc., etc. But he can't touch our LLC. Now, it's important, many people ask, okay, well, does that apply to a married couple? And that question hasn't been litigated yet in Utah. There's a lot of evidence to suggest that a married couple will be treated as a multi-member LLC. So you don't get that charging order protection in a single member LLC because there's no other innocent party. So anytime you own an LLC 100% by yourself, you lose that charging order protection. And the things in the LLC can be sued for based off of things you do personally, negligence you have personally in your personal life. So it's always a good idea to have a multi-member LLC. Percentage splits don't really matter. And if you can own it with your wife, and there's a lot of evidence to suggest that a married couple will be treated as a multi-member LLC. However, the question hasn't been litigated. There are no guarantees of that. So, kind of talked about the flow of risk and liability. All right, so we get to our first LLC type, and it'll speed up from here, I promise. So a standard LLC is just a legally recognized fiction. It's a hypothetical entity that can do anything a person can. An LLC can sign contracts. It can buy and sell. It can hold title to property. It can pay its taxes. It can do anything a person can. It can be owned by other LLCs. It can be owned by trusts. It can be owned by 1 through 100 people or more. Just depends on how you set it up. We talked about how it's taxed, that flow through taxation. Now, before we get to the next LLC, we'll talk a little bit about that flow through tax structure. So under subchapter K, the IRS presumes that all the income an LLC makes is active income. Now that's a bad deal when you're self-employed because that active income is subject to the 15% Medicare/Medicaid FICA tax, also known as a self-employment tax. That's a tax that you normally split with your employer when you're a W-2 employee. You only pay 7.5% of it, typically. When you set up an LLC, though, everything you make is presumed to be active, and everything you make is taxed at that additional 15% in addition to the gross income tax bracket you're in. Okay? So that's a lot of tax. Now, getting to our next LLC, we'll skip that. Getting to our next LLC, the S-elected LLC. The reason people set up S-elected LLCs is to avoid that 15% Medicare/Medicaid FICA tax. You can never get away from it entirely, but you can significantly reduce the amount of tax you have to pay by choosing an S-elected LLC. Now, an S-elected LLC is just a standard LLC, and then you sign a document telling the IRS, hey, we don't want this LLC to be taxed under the S subchapter of the code. Instead, we don't want it to be taxed under the K subchapter of the code. Instead, we want it to be taxed under the subchapter S. Okay? Now, as a quick side note here, many people confuse an S corporation and S corp tax status. An S corporation is just a corporation, like a C corporation. It's a different type of entity. It's not an LLC. They're totally separate. Okay? But an LLC can borrow the S corporation tax status, and it can swap out how it's being taxed by the IRS. The S corporation tax status has a lot of benefits that are really good for a self-employed person running an LLC. Okay, So that S Corp status allows the LLC to designate two different types of income in the business. You can tell the IRS, and you can do a split here. You can say, I believe that 50% of the income this business is producing is active, and 50% of it is passive. So that active chunk of income is still subject to the self-employment tax at 15%, but the other half doesn't have to pay it at all. And you can push that split typically as far as about 70-30. So let's say you made 100 grand this year in your LLC because you're an awesome investor. You can tell the IRS, okay, $70,000 of that is passive income and is coming to me as a dividend. Dividends don't have to pay, passive income doesn't have to pay the 15% tax. Not subject, okay? The remaining 30,000, yeah, you got me. I'll pay the 15% on that. So ultimately, if you net those two chunks of income, you can get that 15% down to about 3 or 4%, which is pretty awesome. So that's the magic of the S-selected LLC. Okay. Then we get to the series LLC, probably the most complicated topic here. I'll break it down simply. It's not crazy. In the context of real estate investment, this is the best possible tool you can have to hold real property by far. Okay. And what it is the standard LLC. So there's a parent company, and that is the standard LLC, right? And then in the operating agreement of that LLC is a paragraph that authorizes it to create series LLCs. Series LLCs are really new. They're only recognized in about 10 or 12 states. So they're not nationwide, but Utah, fortunately, is one of them because it's very proactive towards business. So that parent company has the authorization from the state to at will create clones of itself, child companies or series companies that can exercise all the same powers of the parent company and who also reflect the membership and management of the parent company, but who can hold property entirely separately from the parent company. So to kind of understand this, we'll look at the old dilemma. Before series LLCs were created, if you were a savvy real estate investor, you had two choices on holding your properties. You could either, let's say you had 10 properties, you could either set up one LLC and hold all 10 properties in that LLC. Great, because it's simple on accounting. You only have to pay the attorney to set it up once. You only file one tax return, one bank account, etc., etc. Very simple to run. The problem is, though, when you have 10 properties, any one property can contaminate the other properties with risk or liability. So if one tenant is hurt in one property, they can sue the LLC for anything it owns, right? That includes the other 9 properties in the portfolio, whether or not they had anything to do with the injury. It doesn't matter, okay? So that was good from a convenience standpoint, bad from a liability standpoint. Your other option was be paranoid and set up one LLC for every piece of property. And that was great because it meant at most you would lose one property if a tenant was injured and successfully sued your pants off. And even if they had a $10 million judgment against the LLC, great, we lost one house. The other 9 are in good shape. But the drawback there was, okay, we're doing 10 tax returns, we got 10 bank accounts, we got 10 LLCs, we got 10 filings with the state. It was a nightmare, and we had clients who ran these. With the series LLC, you get the best of both worlds. Series LLC, only the parent company files a tax return, only the parent company has a bank account, only the parent company is set up with the state. But each of the child companies can hold property as though they were a separate LLC entirely. So it's a hybrid where you get the maximum amount of convenience and the maximum amount of asset protection. Each series compartmentalizes the risk in your portfolio, making it so no one property can put the other properties in the portfolio at risk. It's awesome. We can talk about the nomenclature if you'd like after. Essentially, anytime you sign a document, you have to reference the parent company, even if it's the series company that's owning the piece of property. We can talk about that more if you'd like. We'll do a Q&A. Next bit here. This is just kind of a diagram to show you. You've got your members, your owners, and they own an LLC, a series LLC. And then in the series LLC, you have each house titled separately in a separate series. Okay, that's important. That's part of accounting and corporate governance. When you set up an LLC, if you're holding assets with it, you need to title the assets in the name of the LLC. Otherwise, it's as though the company doesn't own them. Take that to the bank. Remember that if you get one thing out of this presentation, if you have an LLC, the LLC has to be the titled owner. You personally cannot be the titled owner and still expect to get the benefits of the LLC. Okay? All right, so that's just another diagram. We can talk about that more if you'd like. Disposable LLCs. This is an amazing tool. It's very, very useful for people who are wholesaling or flipping properties. Essentially, it's a pared down LLC. It's quick to set up. It's very inexpensive. It is a filing with the state that allows you to put an LLC on the contract you're signing, on the REPC. This is incredibly important when you're buying short sales from a bank, for example, and the bank will have contractual language saying that the contract you're signing cannot be assigned to anybody else. It's a real burden on a wholesaler who makes their fee by assigning the contract. Now, what's cool is if you sign that same contract with a disposable LLC, you can still effect an assignment of the contract. The way that you do that is by signing the contract with the name of the LLC. And then right after you do that, you sell your ownership in the LLC to your end buyer, to the guy that you're wholesaling the property to. You haven't assigned the contract. The same buyer is on the contract, the LLC. Just the membership has switched out from you to this other person. And what's extra cool is the manager can stay the same. So let's say I have a disposable LLC in which I'm 100% member and I'm the manager. I sign a REPC for a short sale with a bank in the name of my LLC, Pumpkin Pie. And then let's say Rick wants to buy that contract off of me. Well, I say, Rick, I can't do that. I can't assign you the contract because the bank won't let me. Contractually, I'm not allowed to do that. However, Rick, if you give me a check for my assignment fee, I will sell you the membership in Pumpkin Pie. You will be the 100% of Pumpkin Pie, 100% owner of Pumpkin Pie, which is the buyer on the contract. So you will get the contract, you will get the property. And to top it off, when we go to closing, the manager hasn't changed. Ken Melrose is still the manager on this property. I can show up at closing and sign all the docs and nobody freaks out. You know, where before maybe Rick would have to come in and sign. If he was the manager, who's Rick? We've never seen this guy before in our life. He didn't sign on behalf of the company. You don't have to do it that way. I can show up, I can stay on as the manager after the sale of the membership, and then after I've signed all the closing docs, then Rick can unanimously vote to kick me out. I'm not a manager, I'm not a member. Rick has the property that is inside of the LLC. I've got my assignment fee. We're good to go. Happy to talk to anybody more about that. If you didn't quite catch how that works, I know it took me like 20 times to figure it out. It's phenomenal though, okay? And our bonus for the day, coming up on our final draw here, IRA LLCs. These are a new tool. They are becoming increasingly critical for people who want to manage their own retirement accounts. And what an IRA LLC lets you do is it allows you to actively manage your IRA. So in a normal IRA scenario, you've got your money held in an IRA, which is an entity, tax entity recognized by the federal government. But you are prohibited from managing that money yourself. Can't do it, right? You have to allow a custodian to do it. And normally your custodian will be like TD Price or any kind of big investment powerhouse. And they'll park your money in some kind of safe, mediocre performing stock option, and it'll just sit there and it'll make, a couple percent a year. And they don't want to risk losing your money, so they'll never do anything high risk with it. And that's kind of where your money hangs out until you retire and pull it out. Doesn't have to be that way, however. You can, using an IRA LLC, and a custodian who allows for self-direction basically set up a bank account owned by the IRA LLC, of which you are a member, and the IRA LLC can then be directed by the custodian to buy, I'm sorry, the custodian is the member of the IRA LLC, and then you direct the custodian. You can direct the custodian then to buy properties, to wholesale contracts, to do fix and flips, all without ever actually managing the money or doing what's called a prohibited transaction, okay? So it's important to note that if you're doing a fix and flip, you cannot personally work on the property, right? You have to do everything through contractors, which you should be doing anyway. But if you go over there and swing a single hammer into a nail, technically that's a prohibited transaction, and you can lose the tax-deferred status on your IRA, right? You'd have to pay taxes right then and there for the whole thing. So don't do that. But what's cool about the IRA LLC is that you can leverage your real estate investment knowledge to make your IRA perform far and away better than it ever could sitting in some mutual fund or some safe stock option run by a broker that doesn't care, okay? By way of example, Jeff has most of his retirement money in his own IRA LLC, from which he brokers hard money loans, and he's managed to make that perform extraordinarily well compared to a normal IRA account, okay? All right, we can talk a little bit more about that if anybody wants. Really great stuff. Some other considerations here you want to think about. If you are owning an LLC with an unrelated party, you will also need what's called a buy-sell agreement. A buy-sell agreement is kind of an addendum almost to your operating agreement that contemplates the possibility that one or more of you may die or become disabled. So normally, if you have related members, by kind of the probate laws in the state, the membership will go where it needs to go. Not too big a deal, right? But if you have an unrelated member, let's say Rick and I own an LLC together, and I die, and my membership interest by the probate laws of Utah passes to my wife or my son, suddenly Rick is in business, 50-50 partner, with my wife or my son. What do they know about real estate investing? Nothing, right? And now Rick has to liquidate the company. With the buy-sell agreement, however, there's a life insurance policy placed on me, and if I die, that life insurance policy automatically funds the purchase of my membership. Rick ends up as 100% owner of the LLC. Rick keeps doing business, and my heirs, instead of getting a kind of worthless membership in an LLC they don't know anything about, get a big old check. And those life insurance policies are very cheap. That's kind of the utter importance of having a buy-sell agreement in place. You don't want to end up in business with someone's 6-year-old daughter, right? Now, transfer on death agreements are a provision existing in the operating agreement of the LLC that allow for automatic transfer on the death of a member of the LLC's interest to anywhere that it needs to go. So it can circumvent probate. Generally, you'll have a transfer on death agreement that places the interest into a trust. So as you live, you own your share personally. When you die, it automatically goes to the trust. We can talk about the intricacies of that if you'd like. Generally, it has to do with the multi-member LLC and charging order protection. We can talk about all that in the Q&A if you'd like. Happy to do so. And that's kind of hinting at making corporate planning jive with estate planning. So they often have conflicting goals. There are ways to make them work together. Very few attorneys kind of do both. We've been very fortunate to benefit from the instruction of a lot of good estate planning attorneys, and we figured out good ways to make that happen. So that is the end of the presentation. I'll open it up for Q&A. Put this over here. Here's our contact information, BrillioLaw.com. We have many other hours and hours of high-quality education like this on the website. about various topics pertaining to real estate investment. Really good stuff. As always, if you're confused or have questions or need help, give us a call, 801-560-2180. If this presentation was unclear in any way, please contact us. Happy to help. By way of plugging the class, we are teaching an IRA LLC class, May 30th, 9 a.m. at the Salt Lake City Community College Larry H. Miller campus. You can register online. You can give us a call. We can get you in there. It is the best tool for real estate investors to leverage their IRA accounts, and we will go over all the intricacies of establishing one, maintaining it, avoiding prohibited transactions, and growing your retirement tax-free. It's great stuff. Highly encourage you guys to attend. Okay, so it looks like we've got a question here from Rick Sass. And the question is, if properties are not in a state that recognizes a series of LLCs, what about a hybrid where a master LLC owns a single member LLC, which would own one property? The master multi-member LLC also owns a management LLC. If the renters pay the management LLC, which has a bank account, would I need individual bank accounts for each of the individual LLCs? Would that cause the LLCs to be pierced? That's a pretty complicated question. I like that idea. There's kind of a more efficient means of achieving that end, whereby you can have a series LLC established in Utah, which is the beneficiary of a trust which you use to hold the property in the given state. So that way, the series LLC never shows up on title, just the trust, right? And the beneficiaries remain kind of concealed. So it's a good way for the series LLC to take ownership without ever kind of running afoul of state laws, right? So you get all the tax benefits and convenience of having a single series LLC owning a bunch of properties. And because they're placed in trusts, you never have to worry about the state recognizing the LLC because it never shows up on title. An important kind of note there is when you hold properties that way, you want to make sure that you are titling everything correctly. And you can also have provisions in your operating agreement that say, okay, if there's ever a question of which state law should apply, we choose Utah law. It's called the conflict of law provision. It's extremely commonplace in contracts and operating agreements. And it can just say, okay, if my series LLC owns properties in Georgia and a tenant is harmed in Georgia, the tenant agrees to litigate this as though Utah law applied. Whether you litigate it in Georgia, you can have a Georgia court accept the Utah law that's on point. Or if you litigate it in Utah, obviously it will be Utah law that applies. But you can kind of choose whose law applies. And those contracts and operating agreements are very often upheld. So I like where you're going with the master LLC, hybrid LLC. I think in your example, the kind of subservient LLC would still need to maintain a bank account because it hasn't been authorized by the state not to. That's part of the series authorization here in Utah. The legislature has said, in kind of uncertain terms, but they have said it, that the series doesn't have to maintain a bank account, right? Whereas in your example, the subservient LLC still has to comport with the LLC laws of the state. It would still need its own bank account. So you kind of lose out on that convenience, right? Because it's still filing a tax return. It's still having its own bank account. It's still having to be filed and upheld with the state. So perhaps a simpler way would be to just have a series LLC, which is a beneficiary of trusts that own properties in other states, and have that conflict of law provision in your operating agreement. But that is an awesome question, and I'm so happy we addressed that. That's great. And if I didn't address that adequately, please let me know if you have any other questions. I'm happy to take another crack at it. Worst case scenario, we get Jeff in here and we'll have him shoot an email to you. But okay, any other questions? Anybody else? Okay, Bruce. I've heard that banks doing a short sale won't let an LLC be the buyer on the REPC. True or false? How to get around this? That's really interesting. The offers that I've made, and I probably made about 20 or 30 of them, I think, on short sales where they weren't allowing a assignment of the contract, they were perfectly all right with an LLC being a buyer. In the case that the bank is not allowing an LLC to be a buyer, you could put it in a trust. You could have the trust be the buyer, and you could do basically a substitution of beneficiary, whereby initially I'm the grantor, the trustee, and the beneficiary. When I go to wholesale it to you, we swap out my place. So we swap out the trustee, and we can swap out the beneficiary. And you can be the trustee, or you can have a third party be the trustee, and you can be the beneficiary. But I have heard of banks not being big fans of trust appearing on a REPC. So I think that's kind of a bank by bank basis. Worst case scenario, you buy it in your personal name, you do a double closing, you hand it off to your end buyer. If there's no way you can get on there on the REPC with an LLC or a trust, you're kind of forced to go that route. It's really bank by bank. Some banks don't care, some banks do. So in my personal experience, I haven't seen that with regard to an LLC. I have seen it with regard to a trust, but every bank is different. So if you come across that, let us know. Very interesting to see why that's the case. So, okay. Any other questions? Like I said, this will be recorded. We'll have it posted up on the website here pretty shortly and on YouTube. Oh, no worries, Rick. Just for you, we'll wait. But yeah, as always, if anything's unclear, please feel free to call, and we'll spend time making it clear. Yeah, it's taken me a long time to figure out a lot of this stuff, and I still don't have half the knowledge Jeff does. So. And if anyone else has any other questions, feel free to chime in. I'm not under any particular obligations, so I'm happy to spend as much time here as we need to go over everything. Getting kind of scared, Rick. Are you writing a small novella? And if anyone else needs to bounce or anything like that, feel free. I won't be offended, I promise. Yeah.